Case summary. Case name: Dunlop Pneumatic Tyre Company Limited v. New Garage and Motor Company Limited, 1915. Court, House of Lords. Citation: 1915 AC 79. Decision date: 1 July 1914. Judges: Lord Haldane, Lord Atkinson, Lord Parker of Waddington, Lord Dunedin, and Lord Shaw of Dunfermline. Keywords: liquidated damages, penalty clauses, contract law. Background facts. Claimant: Dunlop Pneumatic Tyre Company Limited. Defendant: New Garage and Motor Company Limited. Facts: Dunlop Pneumatic Tyre Company Limited. Dunlop was a manufacturer of tires, tubes, and motor vehicle accessories. They entered into a contract with New Garage and Motor Company Limited, New Garage, a retailer, to sell their products. The contract contained a clause stipulating that New Garage should not sell the products below Dunlop's listed prices and, in case of a breach, should pay £5 per item as liquidated damages. New Garage sold the products at a price lower than stipulated, prompting Dunlop to sue for the agreed £5 per item as damages for breach of contract. Argument. Dunlop's argument. Dunlop argued that the £5 per item clause was a genuine pre-estimate of loss and thus constituted liquidated damages, not a penalty. They sought to enforce this clause as per the contract terms. New Garage's argument. New Garage contended that the clause was a penalty rather than a genuine pre-estimate of loss. Under common law, penalty clauses are unenforceable, and they argued that the amount stipulated was not a fair representation of the loss suffered by Dunlop. Final outcome and law justification. Judgment. The House of Lords ruled in favor of Dunlop, holding that the clause was a valid liquidated damages clause and not a penalty. Law justification. The House of Lords distinguished between liquidated damages and penalties, providing key tests to determine their nature. According to Lord Dunedin's judgment, these include: 1. A clause will be considered a penalty if the sum stipulated is extravagant and unconscionable in comparison to the greatest loss that could conceivably be proved to have followed from the breach. 2. If the breach consists only of non-payment of money, and the sum stipulated is greater than the sum which ought to have been paid, it is a penalty. 3. There is a presumption, but no more, that it is a penalty when a single lump sum is made payable by way of compensation on the occurrence of one or more or all of several events, some of which may occasion serious and others but trifling damage. 4. It is no obstacle to the sum stipulated being a genuine pre-estimate of damage, that the consequences of the breach are such as to make precise pre-estimation almost an impossibility. The court found that the £5 per item was a reasonable estimate of potential losses due to price undercutting and upheld it as liquidated damages. Key concept. Implications. This case is a leading authority on the distinction between liquidated damages and penalty clauses in contract law. It established a clear framework for courts to determine whether a stipulated sum for breach of contract is enforceable as liquidated damages or void as a penalty. Key learnings. 1. Liquidated damages must be a genuine pre-estimate of loss, not a punitive measure. 2. The stipulated sum should reflect the potential damages anticipated at the time of contract formation. 3. Courts will uphold liquidated damages clauses that meet these criteria, reinforcing the importance of precise and reasonable contract drafting. This case underscores the necessity for contract parties to carefully consider and justify any liquidated damages clauses, ensuring they align with actual anticipated losses to avoid being deemed penalties and hence unenforceable.